Good morning. My name is Erick Kaardal. I'm an attorney who is representing Minnesota Voters Alliance, Andrew Seelick, Kim Crockett, Craig Anderson, Yvonne Hunshammer, and Craig Jones in a very important lawsuit against Governor Walz, Secretary of State Steve Simon, the Attorney General Keith Ellison, the Hennepin County Attorney, the Hennepin County Auditor, the Ramsey County Attorney, and the Ramsey County Auditor. And this all relates to Minnesota's situation where the governor is trying to have it both ways. His poorly thought out executive orders compel upstanding, law-abiding citizens to wear face masks or face criminal fines. In some circumstances, imprisonment. Those same individuals complying with Walz's order are forced to violate long-standing Minnesota law, and by doing so, commit a criminal act punishable by up to 90 days imprisonment and a $1,000 fine. With the specter of threatened prosecution hanging over those who show up barefaced at polls on primary election day, upstanding voters are faced only with the option of breaking another well-established state law. So in Minnesota currently, because of Emergency Executive Order 2081 and Minnesota Statute 609.735, we have laws that if Minnesotans are in public places, it's a crime to wear a mask and a crime not to wear a mask. Prominent criminal defense attorney Tom Gallagher, I think, is on the line, and also Traverse County Attorney Matt Francisi have opined on their respective blog and through a declaration that this is the case. Minnesota criminalizes both wearing a mask and not wearing a mask. I was approached to file this lawsuit because the individual plaintiffs were concerned about their political activities in public places, because on one hand they get prosecuted, the other hand they get prosecuted, and also in-person voting on election day and under the alternate procedures where one can show up in person and vote absentee. So let's go through the complaint and talk about what it means when the state of Minnesota prohibits wearing a mask and prohibits not wearing a mask at the same time. We filed 40-some page complaint, and there's several counts. The first count is about public places and political activity. When the government regulates public places and political way, it's subject to strict scrutiny. Strict scrutiny means the statutes need to be narrowly tailored to meet a compelling state interest. So here, with the state of Minnesota, both criminalizing wearing a mask and criminalizing not wearing a mask, people are fearful of political participation in public places. The plaintiffs have signed a declaration saying they won't engage in political participation in public places because they're threatened to be prosecuted, as the one county attorney has already indicated, if they wear a mask or don't wear a mask in a public place. Count number 2 is reminiscent of the Minnesota Voters Alliance recent victory in 2018 in the U.S. Supreme Court. As you recall, in that case regarding political T-shirts, the U.S. Supreme Court said that Minnesota's polling places are a non-public forum. And so the test is the regulation of that non-public forum capable of reasoned application? And Minnesota lost in the U.S. Supreme Court because its prohibition on political apparel was not capable of reasoned application. And I think this case is much, much worse. Here you have a regulation at the polling place, which stated in the Secretary of State's July 22nd memo, which is attached to the complaint, they intend to take down names at the polling place of people who are violating Minnesota's mask mandate. Which one? Are they going to prosecute the ones wearing masks? Or are they going to prosecute the ones not wearing masks? And this is exactly the election judge discretion that the U.S. Supreme Court in the Mansky case in 2018 wanted avoided in Minnesota. So here we have a decision of the U.S. Supreme Court 2018 regulating our polling places, and Minnesota again is the worst offender of all the states of the First Amendment. This is a horrific state to live in because we violate the First Amendment again and again and again and again. And now we have this recent opinion in 2018, and we can't even follow that. The third count relates to expressive association. The Minnesota Voters Alliance has a strategy, a plan, a purpose of educating the public. And they do that through political participation in public places. So they want to meet publicly, they want to advocate publicly, they want to influence public opinion publicly. And with the mask mandate criminalizing not wearing a mask and the statute criminalizing wearing a mask, they can't do that anymore. They're not doing that. So here you have the state of Minnesota interfering with Minnesota Voters Alliance political activities. Count 4 and count 5 are very similar to the lawsuit that 13 legislators and businesses filed in Ramsey County District Court, which is pending. That is, the governor's executive order doesn't even have legal authority under Minnesota's Constitution. Minnesota's Constitution, unlike the U.S. Constitution in Article 3, has an separation of powers provision. And so the governor can't legislate under our Constitution. And under the statute, the governor has assumed powers that he cannot have to legislate. So the governor can't have a rule, an executive order, or anything that conflicts with the statute. If he wants to amend or repeal a statute, he needs to go to the state legislature. That's count 4. Count 5 is the legislative veto. I have to admit, there aren't any Minnesota appellate court cases on legislative veto, but this statute that the governor is using for peacetime emergency powers has the legislative veto. And since Minnesota has an express separation of powers provision in Article 3 of the Constitution, the governor's executive orders are dead on arrival. The U.S. Supreme Court and all states that have the express separation of powers provision have determined that legislative vetoes are forbidden. The legislature can't veto what the governor does. It's the governor who vetoes bills that are passed by the legislature. So there are so many problems here, but it really comes down to the governor has been using executive powers carelessly. Like I said before, like a drunk monarch. And I said it was going to get worse, and now it's getting worse and worse and worse. And there are more clients calling me about different violations of state law, and we expect this to be a serial or a sequence of lawsuits. And this is the second of that series. So with that, I want to introduce the individual client, and then I'll introduce the representative of Minnesota Voters Alliance and the state legislators. So here's the individual plaintiff, Kim Crockett, to discuss the case.
Thank you, Eric. Good morning. I'm planning to vote in person on the primary on August 11th and bumped into a state statute that makes it a crime for me to wear a mask in a public place. And voting wasn't an exception under that statute. And then I read that the governor had issued an edict that I do wear a mask into a polling place. And if I didn't, I would be reported to the authorities and subject to criminal prosecution. So that's a conflict, and I don't know what to do on primary day. And then if this isn't resolved by the general election, where again, I would like to vote in person. I want the benefit of the legislative process, the back and forth of all state legislators who make the law in our state, not an edict by our governor. And as my attorney, Erick, stated, I have that guarantee under the Minnesota Constitution. I think all of this could be avoided if the governor would just respect the fact the legislature makes laws and then presents them to him. That's the process in Minnesota. And I want that benefit as a voter and as a citizen.
Now, Dan McGrath speaking on behalf of the Minnesota Voters Alliance.
Thanks, Eric. So as Eric said, I'm Dan McGrath. I'm the communications director with the Minnesota Voters Alliance. And it occurs to me as we're going through this that we've been down this road before. Eric made mention of a Supreme Court case that was just settled 2 years ago when the Minnesota Voters Alliance was forced to sue the state over their polling place policy that restricted people's right to vote based upon what they were wearing. Now, in that case, if you were wearing something the state didn't like, they can tell you, we're going to take your name down for prosecution, potential prosecution. That happened to me when I went to vote, when I was wearing an election integrity button in my polling place. And they told me, well, you can go ahead and vote. We're going to take your name down. And you could be charged with a misdemeanor that would carry a penalty of $1,000 fine and up to a year in jail. And that was very intimidating, and I felt was chilling my right to vote and my right to free speech. Ultimately, 2 years ago, the Supreme Court agreed with us and determined the state couldn't do that. Now, this mask has become a form of speech. And the state now, instead of telling me I can't vote because they don't like what I'm wearing, want to tell me, well, I can't vote because they don't like what I'm not wearing if I don't have this mask. And as Erick said, that it's against the law and another statute for me to even put this mask on and go into a public place, for reasons I think we can all understand. So I think this is an extraordinarily important case for election rights and for voting integrity. I'm very happy to be a part of this too.
Thank you, Dan. How about for state legislator, how about Jeremy Munson? Thank you, Jeremy.
Yeah, thank you, Erick, and thank you for leading on this really important issue. I as a candidate, and I have a primary election on Tuesday, and I have voters in my district that have similar concerns as Ms. Crockett. But we have basically a law passed by the legislature in direct conflict with a law or an edict by the governor mandating the opposite. And I think it's really important to get clarity on this issue. For the media, this is not, we're not debating the science behind masks. We're really talking about the legislative process and the abuse of power by the governor to usurp the legislature in writing laws. There was ample time for the governor to work through a process in committees and with the legislature to determine if a new law is right for the people we represent in our districts. And in going ahead and waiting until the legislature adjourns sine die before issuing these mandates, more laws, is really it's frustrating as a legislator to see our powers to write law taken away from us. And I'm very supportive of this lawsuit, and I hope we can get a quick decision. Again, this is to reiterate the points from our first lawsuit. The governor doesn't have the authority to do this. I sit on the Health and Human Services Committee, and heard the bill that would amend 1231 to add into law the governor's ability to declare a peacetime emergency due to a public health crisis. But that bill never passed the legislature, and yet 8 days later he declared these powers to start writing laws unilaterally, and that's very frustrating to see. And I hope that people with this lawsuit and the others will really start to see this as the issue it is, which is the constitutional crisis for our state. And we need to allow the legislature to write laws, and I hope we can get a quick decision on this. So thank you, everybody, for attending today, and can pass it over to another legislator that would like to speak.
All right, well, I guess it's my turn. I'm a state representative, Tim Miller, out of District 17A. My patience has worn out with Governor Walz. This mask mandate is blatantly political and meant to condition people for more control. This isn't about safety. This isn't about a disease anymore. We've drifted away from that a long time ago. I've had numerous people in my district call me and say, what can be done? What can we do? What can you do to get Minnesota back on the right track to address the safety of people, but to do so in a manner that's consistent with the freedoms that we have? People in rural Minnesota don't believe everything that's being told them in the Twin Cities anymore. In fact, they oftentimes mock it, but they're very frustrated. And so I've told them, I've tried talking to the governor. He rejects that. I've tried talking to his people. They don't call me back. We had legislation to curtail what it was that he was doing and end these emergency powers. We were very clear what we wanted to do with that. We wanted to work with the governor to move us in the right direction. And so now I'm at the point to where I have a choice to file these lawsuits or do nothing. I'm going to do what I can for the people of rural Minnesota. They demand that I step forward and stand up and do something right. It's about time that the governor does it, but he's ignoring it. So now I'm hoping that the courts can actually decide in our favor that what the governor is doing both here and with the emergency powers is either unconstitutional or certainly against the laws of the state of Minnesota.
Are there other legislators, or is that it?
That's it.
All right. So I just wanted to wrap up here, and then we can take some questions, I guess, if that's possible, Margaret. So wrapping up, because of the particular situation where Minnesota laws criminalize not wearing a mask, what the position of the plaintiffs are is that we want to politically participate places, and we also want to politically participate by attending the polling place for the purpose of in-person voting. And so, people of goodwill, like the Mr. Gallagher, the criminal defense attorney, and the county attorney from Traverse County, Matthew Francis, these are good people, have said, there's a huge problem here, and that we're basically criminalizing people being in public places. And, it's very embarrassing, but it's consistent with Minnesota's governing ethic of disregard for political rights, political speech, political participation. Every time the Minnesota goes to the U.S. Supreme Court, I've had 2 cases go to the U.S. Supreme Court on the First Amendment. Minnesota loses. Why is Minnesota's establishment so against political participation, political speech, political activities, attending the polling places to vote? I mean, this is a horrific situation. Minnesota is horrific with respect to political participation and political speech and voting. And until the establishment figures that out, the people of Minnesota are in big, big trouble. And here we have the compounded problem of the governor avoiding the legislature to enact executive orders. I mean, this is a monarchy now. We're in a monarchy that may never end. It's very, very sad. So anyway, what we're going to do, because the rights are being violated right through the primary election, and we all know primary elections can be closed, so we need to go to the federal court. And I saw that U.S. District Judge Patrick Schultz was just assigned to the case. And so we're going to go to Judge Schultz. We're going to ask for a temporary restraining order on an emergency basis. And then my clients and the members of the Minnesota Voters Alliance can participate in attending their polling place for the purpose of in-person voting on primary election day, August 11th. So we're going to see if the system works. And so the system should work that people get to vote and politically participate in public places without threat of being prosecuted. That's how the system works. That's First Amendment stuff. That's civil liberties. Minnesota used to be famous for that, but now the establishment doesn't care about civil liberties. They're just thinking about themselves. And so what we're going to do is we're going to go to the federal court and we're suing the government. But our lawsuit isn't about telling the government how to address the pandemic. We're not for masks. We're not against masks. But clearly, there's no scientific rationale. There's no logic behind a response to a pandemic that criminalizes wearing a mask and not wearing a mask. So the U.S. Supreme Court case 1905, Jacobson, upheld a state law in Massachusetts that required compulsory vaccinations. Well, that law doesn't apply here. It's distinguishable because only if the Massachusetts state government had also criminalized taking a vaccination would you have an analogous case. So, how could Massachusetts both criminalize taking a vaccination and not taking the vaccination? Well, that would have been unconstitutional. And you read Jacobson, it doesn't say that state public health laws can't violate the Constitution. If they're unmoored from science, unmoored from logic, unmoored from reason, then they're unconstitutional. And this is what we have in Minnesota. It's very, very embarrassing. I mean, if I had done this, if any of the people that I know had done this, they'd be humiliated. But somehow our government just keeps going along, violating civil liberties, violating the separation of powers clause. Will it ever end? All right, Margaret, we can take some questions.
Okay. If those of you who are want to ask questions, if you could unmute yourself and also do your camera, that way we'll know that you want to ask a question.
Hi, good morning. Tony Webster here, Minnesota Reformer. I'm just trying to understand, is it your position that not wearing a mask is expressive speech protected by the First Amendment?
No, it's not. Our position is that criminalizing wearing a mask and criminalizing not wearing a mask, like the Traverse County attorney has interpreted the law, and so as a leading criminal defense lawyer, Mr. Gallagher, that those types of laws are unmoored from science, unmoored from logic, unmoored from reason, and so they're subject to constitutional review. And so, no, we just want the governor to work with the state legislature to figure it out, because the governor is doing a very poor job acting unconstitutionally on his own.
All right, thank you.
Andy, Courthouse News. Can you hear me?
Yep.
I just had a question.
Yes.
Have you been able to, or have you found out any cases with this existing statute, 609-735, where that has been prosecuted, at least in recent history?
Yeah, you could talk to Mr. Gallagher. He's a criminal defense attorney, but my understanding is that it is brought up. Clearly, the intention of the statute is to have people be identified in public, and there have been over time changes in the wording. But my understanding is it's routinely enforced against people who are usually doing other bad things. But it's worded in such a way that criminal prosecutors can nail, people who are committing robberies and burglaries for just wearing a mask. So if I were, I'm more on the criminal defense side, so I would say that there should be some sort of intent requirement in that statute, or some sort of, it has to be ancillary to another crime. But the prosecutors won the state legislature over on that one, so it's a strict liability deal. You're wearing a mask in public, unless you qualify under one of the exemptions. It's a crime. So, and that's what Mr. Gallagher and County Attorney Francis have found.
Thank you.
Kim, this is Kevin Featherweight, Minnesota lawyer.
Hi, Kevin.
Why would you not wear a mask at a polling place?
That's not the issue this morning. The issue is, why would I, as a citizen of Minnesota, not have the benefit of the legislative process in informing what I do as a citizen on both primary and general election day? That's the question.
So you would wear a mask if this wasn't in place?
Kevin, it's not about what I would and what I would not do. It's that I, as a citizen, am being told one thing by a statute, a criminal statute with no intent written into it, strict liability, and on the other hand, an edict from the governor. So it's not about what I or I would not do. I'm getting conflicting messages from my government, and I'm a law-abiding citizen, and I don't know what to do. I don't know what to do on Tuesday next week. What are you going to do?
I'm going to sit it out. I'm a reporter.
Okay.
You guys, I think Mr. Gallagher had some feedback into the previous question. I'm wondering if he could unmute himself and make that comment.
Yeah, hi. The question about enforcement, I did research that. I didn't find too many cases of the mask crime statute being enforced in court, at least appellate cases that I could come up with. Maybe somebody else could do a better research job than me. However, over my 30 years, I have represented numerous protesters. And when I look at the statute and its origin, it clearly was designed to suppress free speech. Even though we probably would all agree that the Ku Klux Klan is bad speech and it's hate speech, it still is free speech. And that's what the law was originated to do. I'm not sure that it ever was enforced against any of those people, but that in 1963, that it was sweeping the nation, those kinds of laws. And it hasn't been enforced much at all. And I argue that because it hasn't been enforced, it should be repealed. You know, if you have something sitting in your basement for 20 years that you've never used, maybe you should throw it out, because we have so many laws, we could probably live with fewer of the laws. However, even though I haven't seen a lot of criminal enforcement of that law, and again, that's a reason to repeal the law, I wrote an article in March calling for the repeal of the mass crime statute, because we should have done it a long time ago, but especially now during this pandemic response, so that people would be free to wear a mask if they chose to do so without fear of criminal prosecution. However, in my years of representing protesters, which are essentially, or they are all free speech cases because they're protesting political issues on all ends of the political spectrum, although more often on the left end of the spectrum. Many of these protesters have been arrested wearing masks, and law enforcement has, arrested them based on this mask crime law. They can rely upon it for probable cause. They can rely upon it to arrest someone, even though the prosecutor may or may not use their prosecutorial discretion to later charge under that statute, as opposed to many other statutes that they have available to them, such as disorderly conduct or whatever else there may be. And as long as I'm talking, I'll throw in one more comment. I wrote another article recently after the governor's executive order pretending to mandate mask wearing in public, where I criticized that, saying that it was illegal and unenforceable because my perspective as a criminal lawyer, and also from an administrative law perspective for the lawyers out there, at least to know what that means. Generally speaking, if the executive branch wants to enact a rule or an order, it can only do so to the extent that legislative powers have been delegated by the legislative branch. And the courts look to the legislation that enabled that administrative action or power to delegate. And in this case, there is a statute that sort of does that. But when I look at the statute, it says that the governor's executive emergency order can override rules, which clearly means administrative rules of the executive branch, and local ordinances of subdivisions of the state, which clearly means like Minneapolis City ordinances or Hennepin County ordinances. But by naming those things and not naming statutes, clearly it doesn't delegate the power to the governor to override Minnesota statutes. So it's illegal on that basis as well. And from a criminal law perspective, I feel that I can easily defend and win any case where someone is charged with a crime of not wearing a mask in public, because there's a statute that says it is a crime to wear a mask in public. And that's a state statute, and the governor's order is administrative, executive branch, and inferior to any state statute. When there's a conflict, the statute always overrides an executive branch administrative order. That's basically my analysis in my article.
Thank you, Mr. Gallagher. I really appreciate your public service in writing those blog pieces. They're very valuable. And I just wanted to thank you. I admire your work.
Margaret, do we have any other questions?
Yeah, can folks hear me? It's Bill Werner at MNN. I don't know if we're queuing up, or everybody can hear me? Okay, good.
Yeah, we can hear.
Yeah, good. I guess this is probably a question for Mr. Kaardal. If you prevail in this, then masks will not be required at the polls next Tuesday. But my question is, the fundamental issue is a conflict with the governor's executive order versus an existing statute. If I'm understanding this correctly, this is what your contention is in the lawsuit. Why did you do it now? Why are you waiting till now? The mask mandate's been in effect for a little while anyway. The principle goes, I would assume, beyond just the election. Am I correct, or am I missing something here?
No, you're right. I'm kind of echoing Mr. Gallagher's points. I did not, Mr. Werner, I did not think, based on the U.S. Supreme Court case in Jacobson upholding Massachusetts compulsory vaccination laws, that there's going to be a way to get it into federal court on any of these claims. If you'd imagine, a federal civil rights claim, narrowly tailored to a compelling state interest, well, fighting a pandemic is a compelling state interest. So the government can do anything, really. But then when this situation came up with the mask mandate, these clients approached me and said, well, this is a problem. Back to me from problem. And then
Eric, you're cutting out here if you want to just
If
back
they're-
up a couple sentences.
And then the Travis County attorney called me, and then I started thinking. I said, "Oh, the issue here is that the Minnesota has both not, so they left the state harbor of science, and so then the federal court would take the case. And even in the Jacobson opinion, 1905, it said, you know, these are local."
We lost Eric.
Anybody else care to tackle that question?
Well,
No, I would just say it's all in the brief. It's laid out very carefully in the brief if you want to go to that section.
and I would just add that, you know, we're already in a lawsuit against the governor's executive powers as laid out, I think, in point number 4 or 5 of this lawsuit. And because it now crosses into federal issues with elections, that's why this is so important to handle in federal court. Eric's back on now. Sorry, Eric, you want to pick up where you left off?
Yeah, sure. That basically that when we saw when these calls came in, I realized that there was a federal claim because the Minnesota's policy of both criminalizing wearing a mask and not wearing a mask is not moored by science, logic, or reason. And Mr. Gallagher has pointed out there's no way that the governor, attorney general, and the county attorneys can win a case in state court for not wearing a mask because the law is you have to wear it. And so that's the type of thing. It's very, very narrow, but it's very narrow. But you're right, Mr. Werner. You're correct to say that if we prevail on the temporary restraining order, the governor won't be able to enforce his mask mandate unless he works with the state legislature, which he should have been doing all along. Now,
Right.
the plaintiffs are taking a position on what should happen at the state legislature. We're just taking a position that right now it doesn't work.
The point that you're using to pursue this lawsuit is the election, the primary election. And I'm just trying to understand your strategy for doing that as opposed to just, you know, saying generally, hey, we've got 2 conflicting statutes here that apply broadly, not just beyond the election. But can you, maybe without letting cats out of the bag too much or whatever, why did you choose to have the election be the point, be the event that you're forcing this legal point on? I think maybe we lost.
Oh, that's a good question, Mr. Werner. I would not have included the focus on the election. I'm here. I can see you. So I did not would not have focused on the election, except the Secretary of State put out a memo to election judges to take down names for prosecution, and that's Exhibit 2 to the complaint.
Okay, and have you got any comment on the Secretary's action like that? What's your opinion on that?
Well, it's the same thing that happened in Mansky. So we won in the U.S. Supreme Court in 2018. So we go to number 2, and he's directing county auditors, including the 2 that are named, the Ramsey County, Hennepin County auditor, and he's saying basically that the election judges should determine who is wearing a mask, and if they're not wearing a mask, take down their name for prosecution. And meanwhile, you know, the same election judges can refer those who are wearing a mask to the county attorney for prosecution. So that kind of election judge discretion and county attorney discretion is, you know, it's just wrong. As Mr. Gallagher said, what a mess. I mean, no prosecutor can win on enforcing the governor's edict because there's a law saying the opposite.
Okay, yeah, that's very clear now that you bring up that, and I'll take a look at that exhibit, Mr. Kaardal. Thank you very much. Very clear.
I want to add to Steve Drazkowski here, Bill. If you read the governor's executive order 8001,
Yeah.
I think he he and his people knew they're in conflict with this law. There's no way they were able to get around it. They just basically said in there, guess what? This edict doesn't violate that state law. That's what he said in the order. Now, you figure out what that means and where that goes. That is really a weak way out of him realizing, or his people realizing, that they're in the wrong place here.
Appreciate you mentioning.
Right, and
Thank you.
on the Attorney General, you mentioned Mr. Werner, the Secretary of State. The Attorney General right now, as I understand it from the newspapers, is going after the rodeo in northern Minnesota under the same sort of theory Mr. Gallagher is discredited. Now, Mr. Gallagher, you can run around and defend all these Attorney General prosecutions. I'll refer them to you, and I hope you do, but that's no way to run a state. I mean to have basically anyone who goes out in public can be charged under one law or charged under the other. And when you have a county attorney saying this is wrong, Matt Francis in Traverse County, people's concerns about going out in public and violating the law are a thing. Now, generally, fear of violating the law is a good thing. We encourage that, but not if those laws make going out in public criminal.
Thank you very much, all.
Thank you. Margaret, are there any more questions?
I don't see any.
All right. Well, thank you for attending our press conference. We'll be filing the motion for temporary restraining order this afternoon or tomorrow morning. We'll be serving the other parties, and we expect to have a hearing before the primary on August 11th. And so we hope that you can come back. We'll have a press conference related to that too. Thank you so much.